Good morning, and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. We are located at 1563 Main Street in Peckville. I am here every Sunday from 8 to 9 a.m. to provide landowners valuable information you need regarding the natural gas development here in Pennsylvania. If you are looking for landowner information, this is the show for you. And of course, at the Clark Law Firm, my focus is on landowner and only landowner representation. And I have and continue to represent Pennsylvania landowners all across the state for such items as gas lease negotiations, pipeline and water line agreements, royalty and royalty deduction issues, which we're going to talk a lot again about today. It's going to be the focus of the show, but also with gas and pipeline company disputes, doing a lot more with unitization issues, estate planning, succession planning, as more and more landowners are starting to transition into the royalty phase of their lease, doing a lot more work in that area as well, but also damage releases, well site agreements, meter site, compressor site agreements, essentially any contract or issue related to the natural gas development here in Pennsylvania. And one of the things, I've talked about this before, I mentioned statewide representation. I've represented clients as far away as London, and just recently I've talked about Micronesia. So, distance has never really been a factor in any representation to date. So if you're interested in representation, you want to learn more, a couple things. One, you give us a call, 570-307-0702, or I encourage you, go check out the websites. Even if you're not looking for representation, a lot of great landowner information available there. Number one site is pagasleaseattorney.com. The second site is pipelineattorney.com. And another thing we do here, we made the transition to the new stations recently, and what we're doing now, because I want to make sure the show is available to everybody right away. So we're starting to post today's show, will be up on the site tomorrow. So that's what we're looking to do moving forward. So if you can't make it each Sunday from 8 to 9 a.m., you can go to the websites at pagasleaseattorney.com, check out the show the next day. We'll keep that show up all week, and then we archive those shows then, so they stay available. Just you're going to go back to the archive section. So they stay available, and now we're over 140 hours of shows. So really covering the whole gamut of leasing, pipelines, you name the issue, we have it. Special guest shows, all those shows are up and available. Been doing the show since August of 2010, so 140 plus hours available there. pagasleaseattorney.com or pipelineattorney.com, and of course we're here every Sunday from 8 to 9 a.m. Another thing, if those aren't enough ways to get access to the show, you can check us out on iTunes. There's a free podcast. We have all the shows up there. Just go to the podcast section. You can type in All Things Marcellus. And again, you can download the shows there and listen to them whenever you would like. And also, you can follow me on Twitter at Doug Clark Law. Really try to keep tweeting some articles and some comments, things like that, but a lot of information too that we're putting out there on Twitter. So if you're into that and you want to check that out, encourage you to do that as well. Okay, turning to this week's topic. The last couple of weeks I've talked a lot about royalty deduction issues. I'm going to continue to do that today, and this show I think is going to be very interesting. And it's going to be interesting for a number of reasons, and I'm going to try to make this as easy to digest and understand as possible, because I am going to be talking about numbers, but we're going to try to make these numbers I'm going to try to present them in a way that are going to be easily understandable to you, the listener. So if it is a little bit complicated, or if you need to hear it again, remember you can go to pagasleaseattorney.com tomorrow, Monday, check it out. We'll have the show up there so you can get that information. And also, if you ever want me, I can typically email you a link to a show. You can contact us directly at 570-307-0702. That's 570-307-0702. Now, also, I've talked a lot about the royalty deduction issue, and that's also in many other shows in the past that you can find on the websites. All right. what I'm going to do, I'm going to reset again here this first segment, and then I'm going to spend the next 3 segments really breaking down some math, some real landowner royalty statements, and what the impact of these deductions are having at the present time, what they would have if the DemCheck's proposed class action settlement is approved, and not only just on a Chesapeake lease, but we're going to go step out of Chesapeake. We're going to look at another company as well. And this to me is some unfortunately fascinating stuff, but fascinating to the negative. So it's really important. You're out there, you're listening, you're hearing about Chesapeake, you're hearing about these things, and you say, well, they don't apply to me because I'm leased to Cabot, or I'm leased to Southwestern, or Talisman, or WPX, and the list goes on. So I don't need to worry about this proposed settlement that everyone's talking about in DemCheck versus Chesapeake because I'm not leased to Chesapeake. Well, there is a big concern. What will happen if this proposed settlement is approved? What is going to be the fallout of this? What impact will it have on you if you're not leased to Chesapeake and you're leased to another company? And we're going to get into that today. And unfortunately, I think that answer to me is a scary answer, but we'll let you guys be the judge. Okay, you're listening to All Things Marcellus with me, Attorney Doug Clark, and want to jump to it now, resetting. And please bear with me if you've been listening consistently, but we need to reset this for new people here. Okay. So what we have is post-production costs that are being deducted from landowners' royalty checks. And here's what's important. What I'm going to be focusing on today is landowners who have what's called the Market Enhancement Clause or similar language. And that's really, really important. And also the words or similar language is really important. There's another clause that says to the effect of there will be no deductions to make gas ready for sale or use. So I often refer to that as the ready for sale or use clause. So those people who have that language in the lease are going to fall into this proposed, and I can't say it enough, proposed class action settlement in DemCheck versus Chesapeake. So but in order to determine, do I have this language, it's not just that simple. Sometimes you can easily pick it up. Sometimes it's more difficult, and sometimes you really got to sift through that agreement, and some of these leases can be 20 plus pages long. Sometimes they're much shorter. So one of the things that I do is anybody who is interested, I offer a free, confidential, no obligation evaluation to let you know, does this proposed settlement apply to you? Do you have this language? And then what you do with that information from there is up to you. This is what we're looking at. We're looking at, does this apply to you? Because you need to understand this in order to make the right decision for you. Okay, so that's what we're going to be doing. We can get a free evaluation at any time. Contact my office directly, 570-307-0702. All right, now resetting. What are we even talking about here? We're talking about, in this case, we're going to talk a lot about Chesapeake. So we're going to say that Chesapeake, and that happens with other gas companies, are deducting what are called post-production costs from landowners' royalty checks. Now, in some cases at the present time, this is a very legal activity to do. If your lease allows it, there's a U.S. or Pennsylvania Supreme Court case of Kilmer versus Alexco where the Pennsylvania Supreme Court said, yes, you can deduct post-production costs from a landowner's royalty checks as long as they're getting the guaranteed minimum royalty of 1/8 or 12.5% at the wellhead. Okay, again, I'm going to explain this. What does that mean? Well, gas is produced, it comes to the surface of the ground, and that's at the wellhead. So the surface of the ground, where gas literally comes up from beneath the ground to the surface, goes to the wellhead. Those are production costs. The costs that are involved in drilling, clearing the property, fracking, all of those costs are costs to produce gas. Well, what are post-production costs? Well, those costs are costs incurred after the gas gets to the surface of the ground. So, post-production costs, very common examples are gathering the gas into the pipeline system, transporting the gas through the pipeline system, compressing the gas, getting that pressure up within that pipeline system, and sometimes even within the well system. But then also we have dehydration, there can be separation of liquids, and there's other processes that can take place as well from the time that gas hits the surface until it gets to this downstream point of sale. Now, for our example, we're going to use a common point of sale as the interstate transmission pipeline, which very often could be, for example, the Tennessee gas line, the Millennium gas line, the Transco gas line. Very common examples of interstate transmission pipelines. So what happens is gas typically is not sold at that surface or at the wellhead. It is gathered, transported, dehydrated perhaps, compressed, and maybe other processes occur to this or performed on this gas in order to get it to that point of sale and then to make it where it's going into this interstate pipeline, and we'll say it's going to, for our example, be sold at that interstate pipeline. So what do we have then? So we have there's cost for gathering the gas, transporting the gas, compression. We'll use those for this example. So say hypothetically that the gas is sold at the interstate transmission line, a Tennessee line, we'll say, common example I use, at $4 per 1,000 cubic feet. So if you had no deductions on your royalty checks, you would see that you would be paid, and we'll use an example, we'll say a landowner has 15% royalty for my example. So you would see on your royalty check that you were getting royalties based on $4 per unit or 1,000 cubic feet of gas. That's good. Okay, so that's very simple. Now, what happens is when you have deductions, which are commonly called deductions here, we hear that term all the time. Well, what happens is you may see that the gas is sold at $4, but you'll see these, what they call codes, and it's no scientific or anything. You can have a letter T representing transportation. You could have a letter G representing gathering, big shock, C, compression, and so on. So what happens is you'll see that there are these deductions, and you'll be charged costs for transporting the gas, gathering the gas, compressing the gas. And so ultimately what they do is they subtract or deduct, the gas company does, these costs from that sell price. So let's say the total of a cost is $1. My example, I use this all the time for ease of reference. So what we're saying is that maybe it cost 75 cents to transport it there to the interstate pipeline from the wellhead. Maybe it cost 15 cents to gather the gas per unit, and maybe it cost 10 cents to compress the gas. And again, I'm making up these numbers just to come up with the dollar here. So, okay, so what happens is when you have these deductions, now you're talking about $4 it was sold at, but there was $1 in post-production costs of gathering, transportation, and compression in my example. So the landowner, instead of having their 15% royalty calculated at $4, they have it calculated at $3. So what we're saying is if you have the market enhancement clause or the ready for sale or use clause, there should be no deductions taken from your check. You should be paid 15% royalty on $4 gas. They shouldn't be able to deduct those transportation, gathering, and compression costs. So again, what is the market enhancement clause? Well, just giving you a brief version of this here, it says something to the effect of there will be no deductions for gathering, transportation, marketing, compressing, dehydrating, and so on. It keeps on going. It says in order to make the gas marketable or to place the gas in a marketable form. However, anything done to enhance the value of gas may be deducted. Okay, and this is again very much of a paraphrase, and I encourage you, if you want to know if you have this, if this qualifies, if you're a part of this, 570-307-0702, give you a free, confidential, no obligation evaluation. I really, sincerely want everybody to understand, does this apply to you? What you do with that from there, as always, is up to you. Okay, so if you have this market enhancement clause, my position, the position of the attorneys I'm working with, and the arbitration action we're filing and our intervention that we filed in federal court to challenge the proposed DEMCHAC settlement is that the landowner, if you have this market enhancement clause, ready for seller use, or similar language, is entitled to 100% of their royalties, that at $4 sale price. Not the $3 price, but the $4, and you can't deduct anything, company. Nothing. And that's been our position. Now, the proposed settlement in DEMCHAC, which applies to any landowner who has the market enhancement clause or similar language, applies to everybody. If you're leased in whole or in part to Chesapeake, would say that dating back prior to September 1st, that Chesapeake, if they took deductions, would pay you back 55% of the deductions they've taken up to September 1st of 2013. After September 1st of 2013, moving forward to the end of time, Chesapeake, under the terms of that lease, would only have to pay the landowner 27.5% of the deductions they have been taking. Obviously, our position is it should be 100%. So what that means is if this settlement were to be approved, which we're challenging and we're fighting, if it were to be approved, and if you participated, if you did not opt out and you participated in this settlement, then if you had $1,000 of deductions in a month, instead of getting that $1,000, you would only get 275 of those $1,000 that you, or that $1,000 that you were owed. Okay, well, I'm way past my time here, but I wanted to really get through this. I'm going to touch on this again, and then we're going to talk about some numbers. What does this really mean? Practically, what does it mean? You're listening to All Things Marcellus with me, Attorney Doug Clark. We'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. And again, I want to remind everybody, this is so important, and I really want to make sure that everybody understands whether this proposed settlement, and remember, this is a proposed settlement. This has not been approved by the federal court. Unfortunately, there's some articles out there that did not report it properly at the beginning, and it's been picked up by some other newspapers as well. But I assure you, this proposed settlement in Demchak versus Chesapeake has absolutely not received preliminary approval or any approval from the federal court. They're seeking approval, and that's where we have sought to intervene on behalf of our current clients, who now total 160 individual clients consisting of over 5,000 acres. And also, the Wyoming County Landowner Group, a representative has written to the federal judge in the Demchak case, also voicing their very strong opposition to this proposed class action settlement. So there is a lot of opposition out there. In fact, I personally have not spoken to, and I speak to landowners every single day, except sometime on the weekends, but every day in speaking with landowners and other attorneys who represent landowners, aside from the attorneys in the Demchak case, I haven't seen anybody or talked to anybody that says, hey, I think this is a good settlement for landowners. That's your call as an individual in the event that this applies to you. But you have to know, does it apply to you? So, for a free, confidential, no obligation, I stress it, no obligation whatsoever, I will look at your lease and say, I will look at your lease and tell you whether you have this language and whether this proposed class action settlement would apply to you if it were approved. Remember, we are actively challenging this. We do not feel that this is appropriate, and we believe that landowners with these leases should be paid royalties in the same fashion that Statoil is paying their royalties, that Cabot is paying royalties with this language, that WPX is, that Talisman is, that Southwestern, and the list goes on, Mitsui. We believe the landowner should be getting 100%. One thing I want to correct quickly here is last week I used the wrong number, and I want to set that with, a lot of people think, okay, well, I don't want to do anything because if I don't do anything, I'm not going to have to pay attorney fees. Well, in a class action case, what happens is that the court, whenever they approve, if they approve a class action settlement, there's going to be attorney fees requested in that process. And in the present case, the Demchak Council has requested to be approved by the federal court attorney fees where they will be paid for all the past recovery. So that money, remember, just again to explain, prior to September 1st, 2013, there were deductions taken by Chesapeake for post-production costs. Okay, so prior to that time, landowners, where they had 100% taken, would actually receive 55% back. So they'd be reimbursed back 55% of the money that was previously taken. Now remember, that's only prior to, that 55% is only prior to September 1st of 2013. Well, attorney fees that are requested are 33 1/3% that would apply to that. Now, the estimated recovery for that back payment, okay, of that 55%, what money would be owed to landowners, is estimated, and I stress this estimated because we don't know what that number is at this point, is estimated at $7.5 million. So 33 1/3 would be about $2.5 million. So that's applying, okay, if it were approved and the numbers are approved, that the fees are approved. And also, going forward, landowners would only receive 27.5% of those post-production costs that are currently being deducted. So back to my example I used in the first segment, that example of if there were $1,000 in post-production costs deducted in a single month, well, that landowner would be getting 27.5% if this settlement were approved, which would be $275 out of $1,000, where Statoil under the same lease would pay the landowner $1,000, as would many other companies. So we're saying, no, that's not high enough. Now, the attorney fees that are requested, and if approved, would apply for 5 years into the future after September 1st. So instead of, in this example, instead of the landowner getting that 55%, instead of getting 55% of those deductions that they're reimbursing prior to September 1st, 2013, the actual number that the landowner gets would be 36.685%. So about 37%. That's after attorney fees. And the point is, look, there are attorney fees involved with any attorneys, including ourselves. But it's important for landowners to understand that if a settlement is approved, and if you don't opt out and you're a part of it, the court will approve and apply attorney fees across that class. So by sitting there, I know I've talked to people, and I've talked to people that have talked to their friends and said, well, hey, we won't do anything and we won't have to pay any fees. Well, it's not going to be how this works out, and it's important to you understand that they're going to be appointed now or approved by the court. Again, I'm not saying you have to do anything. What I'm saying is you have to understand these things and make a decision. Like I said, we represent 160 individual clients. I believe there are 13 individuals in the proposed Demchak versus Chesapeake settlement. I've talked to countless landowners, and I haven't talked to anybody that feels, again, that this is a good deal. Okay, I am Attorney Doug Clark, and you're listening to All Things Marcellus. And now, want to talk again. Oh, and I want to hear my correction was last week. I think I said that. Okay, moving forward, and this is important, 27.5% is what the landowner would receive after September 1st of 2013. 27.5%. But for 5 years, if this were approved and the fees are approved for the attorneys, for 5 years from after September 1st, the attorney fees will be 33 1/3% of that recovery, of those post-production costs, not the entire royalty check. Just that amount of the difference. Those gathering, transportation, compression, and so on charges, now you're getting 27.5% on, if approved. The attorney fees of 33 1/3 would apply for 5 years. So the landowner, instead of getting 0% or 100%, which we think they should get, they would actually get, for the first 5 years, instead of 27.5%, they would actually get 18.3%. And I think last week I said 18.1, and I apologize. It's actually 18.3%. So if, just making a simple example, if there were deductions of $1,000 a month, for the first 5 years, instead of the landowner getting $275 or 27.5%, if this were all approved and you participated and didn't opt out, and this were approved the way it is, and the attorney fees were approved, for the first 5 years, instead of getting 27.5%, the landowner would receive 18.3%. So out of that $1,000, it would be $183. However, after 5 years, once the attorney fees phase out, the landowner now, in this $1,000 example, instead of getting 18.3%, that landowner would now get 27.5%. So it would bump up from $183 up to $275. So I want to correct that, because last week I think I said 18.1 or $181. I am Attorney Doug Clark. You're listening to All Things Marcellus. And now, okay, I want to jump into some real mathematical examples. I'm going to do the best I can to make this easy to understand, and again, encourage you to go back. We'll get this show up right away and go to pagasleaseattorney.com. Listen to it again. Listen to these numbers. I'm going to give you some real example of numbers, and I think this is very, very important. I want to also say, if you're saying, okay, hey, does this apply to me? I want to know. Contact me, 570-307-0702. Free evaluation, confidential, no obligation whatsoever. Let you know, does this apply to you? Because if you have this language, this market enhancement clause, ready for seller use, or similar language, this applies to you if you're leased to Chesapeake in whole or in part, meaning just a part of your lease, and it's whether you're currently receiving royalties or not. You do not have to be receiving royalties for this to apply to you. And many people don't understand that as well. You do not have to be receiving royalties for this to apply to you. Okay, what I want to do, and one of the other big concerns that I have about this settlement, aside from the fact that I don't think it's appropriate, I think it's too low for many, many reasons. But aside from that, another concern, say you're out there, you're leased to Cabot or Southwestern, WPX or Talisman, and you say, well, hey, look, thank heavens I'm not leased to Chesapeake. This thing doesn't apply to me. Well, here's a question. What happens if this were approved and moving forward, instead of taking 100% of the deductions, Chesapeake now takes 72.5%? What are companies like Statoil, who's paying under the same lease, Mitsui, who's paying under the same lease in many cases, what is Cabot, who is paying under the same language to different landowners, in Southwestern and Talisman and other companies, WPX, what are they going to do? So what I did was I took one of my clients who is getting paid from another company. And in this particular case, this landowner receives a royalty check for 1 month of production. So I'm just going to look at 1 month of production from a client of mine who's not leased to Chesapeake. Now, this landowner is being paid without any deductions being taken. And they have the language that if they were leased to Chesapeake, the proposed Demcheck settlement would apply to them. Okay, so they have this language. But they're leased to a different company, and this company is not taking any deductions. Well, this landowner is part of a good unit, and his total royalty for 1 month of production from one well. So we got 1 month and one well producing. Very nice well. Guy has some good acreage. His royalty check for 1 month and one well was $11,378. So that's 1 month royalty check, $11,378. Now this company, who is not taking deductions, actually shows or demonstrates on the royalty check what the deductions would be, shows what the costs actually are for gathering, transportation, compression, and so on. They actually show that on his royalty statement, even though they are not taking deductions. So this landowner and I can look at their check and say, well, geez, they're not taking deductions, but if they were, we can see what they are because they're showing us, which also makes me very nervous. In the event they change their mind and approach things differently, they've already shown and we already know exactly what those deductions would be. So that's another major concern. If they change their mind and go retroactively, it's already right there in front of us. We know what these deductions are. Okay, so again, one landowner, 1 month of production, one well that's producing. His monthly royalty check, and this is a true check, was $11,378. Okay, they show deductions. This company shows that we're not taking deductions because you have this language. But if we were taking deductions, there would be a total deductions of $2,233. So we're paying you $11,378. That's what he actually receives in his check. And we're not taking any deductions because you have this market enhancement clause or similar language. So we're paying you 100%. If we weren't, the total deductions that we have, but we're not charging you any, are $2,233. So the difference in deductions, when you take the amount the landowner actually gets, is $11,378. $2,378. The deductions, which in this case none are taken, will be $2,233. If 100% deductions were taken, if 100%, so if he released the Chesapeake instead of this other company, he would receive, the other company pays him $11,378. Chesapeake would deduct 100% as of now and only pay him $9,144. So that $2,233, those deductions for 1 month, which are shown on the check but not taken by this company, if he released the Chesapeake as of now, they would take 100%. We get back after this break. I'm going to get into this some more, and we're going to talk about what could happen in the event this company changed positions, and which could happen if the Demcheck settlement were approved and this company decides, hey, why should we pay 100% when Chesapeake is only paying 27.5%? We're going to get into those numbers right after this break. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, and I'm going to jump right into it here. What we're talking about, picking right up from the last segment, is a landowner client of mine, Pennsylvania landowner, who is receiving royalty statements and royalty checks from a company, not Chesapeake, and in this monthly statement, in all his monthly statements, this company actually lists what these post-production costs are in his royalty statements. But they're not taking those costs, but they list them, which concerns me in some ways because, boy, it will be pretty easy for this company, if they change their position as they watch this Chesapeake case, to go back and say, hey, look, here's what our post-production costs were. Now we've changed our position and we're going to start deducting. And what if they decide they're going to start making this, or they're going to go retroactive and say, look, we've been paying you 100% of these post-production costs. We have incurred them all and we've not passed any on to you, and we're going to change our position. Okay, very big concern of mine, and certainly I think should be of other Pennsylvania landowners. Okay, so in this example, we have a client of mine, Pennsylvania landowner, who in this particular month receives a royalty check totaling $11,378. The deductions that are not taken but are specifically listed on his royalty check are $2,233 total dollars. So, if he released to Chesapeake right now and Chesapeake took 100% of these deductions, he would only get, instead of $11,378, he would only get $9,144. Okay, so good for him now he's not leased to Chesapeake, because that's $2,200 plus a month. So just playing that out, and these would change all the time, but if you times that out over the course of a year, you're talking about, if it's $2,200 plus a month, you times that out by 12, you're up over that $25,000 difference in a year. Now, remember, this is one well only. What if there were 6 wells? And these numbers were multiplied by 6. Now, I stress, I'm just giving this as an example because these numbers are going to change, they're going to fluctuate. There may not be ever 6 wells in this unit. There may be 2. There may be only 1 forever. There might be 10. But throwing that out there of things to think about. Remember, this proposed settlement would apply for the lifetime of the lease. The lifetime of the lease. So if we're talking about 20, 30, 40, 50 years, that's how long this proposed settlement will apply for, the lifetime of the lease. So let's go ahead and run these numbers a little more. Let's use this example that if Chesapeake's proposed class action settlement were approved, and let's say that this landowner in my example, who is not, but we'll use the example, what if he released the Chesapeake? How would this apply to him? Well, instead of him currently receiving the full amount and the company not taking any deductions, and those deductions in this month were $2,233. So instead of the company paying him, who now pays him 100%, gives him that full amount of money, doesn't deduct anything. If this were Chesapeake, they would right now just take that $2,233 and keep it all. Well, if the settlement were approved, Chesapeake then, and we're not going to calculate attorney fees for now to make this simpler, Chesapeake then would be allowed to take 72.5% of those deductions. Again, the deductions in this given month are $2,233. So instead of paying the landowner $2,233 after deductions, after this settlement, if we pretend that this landowner is leased to Chesapeake and this settlement is approved, the landowner would receive $614 out of the total deductions, which are $2,233. So let me explain this again. I know it can be tough with all these numbers over the radio, so I'm going to slow it down and explain it again. We have total deductions in this given month by a single landowner who is not leased to Chesapeake. But we're going to pretend to illustrate what this settlement means to people, but then also, what does this mean if this settlement were ever applied to other companies followed this? Now, again, they're not going to follow it exactly. They can't. There's a whole bunch of process involved there. But I want to explain this as, what if this person were leased to Chesapeake, but then also something to think about, because they're not leased to Chesapeake, but how could this impact you as a landowner in the future if you have the market enhancement clause, if you have the ready for sale or use clause, and you're not leased to Chesapeake? But what if this company says, hey, why should we pay the landowner 100% and not take any deductions when Chesapeake is taking 72.5% of deductions if the settlement is approved? Okay, so again, resetting here. In this case, we have a royalty check without deductions of $11,378. The company shows on the royalty statement what the deductions are, but they don't take them because this landowner has the market enhancement clause or similar language. So they show that without deductions, the royalty payment and what the landowner receives is $11,378. The deductions, which are not taken but are listed, total $2,233 for this 1 month. So the landowner now, if the release to Chesapeake, would not get the $11,378, but Chesapeake would take 100% of these deductions and would take $2,233 and keep all of that money and pay the landowner only $9,144. If the settlement were approved and if it were applied to this example, the deductions of $2,233 for 1 month, Chesapeake, instead of taking 100% of that money and keeping it, would now only keep 72.5%, and I use that word only, 72.5% of the deductions. So instead of Chesapeake keeping the current deductions of $2,233, they would now, post-settlement in Demcheck, keep $1,619. So instead of keeping $2,233, they would keep $1,619. The landowner, instead of receiving $2,233, those are the total deductions. So the landowner would only receive $614 out of the $2,233 of total deductions. So, wrapping that up, that under the Demcheck settlement, if it were applied to this landowner who now would receive from a different gas company no deductions. So with no deductions, this person's check is $11,378. That's how it's paid right now. That's what, for example, if Statoil were paying this, they would pay the landowner $11,378. But if the settlement were applied to this example, the landowner would only receive a check for $9,758 versus the money he's currently receiving, which is $11,378, and that's without any deductions. So again, the concern here is there's a lot of concerns, but the concern for this particular landowner is, hey, I'm leased to a total different company. I have the market enhancement clause or a similar language. I'm not leased to Chesapeake at all, so this doesn't apply to me. Well, that's true, but remember, look at your check and say, wow, this gas company is showing what these post-production costs are. My check shows that I have gathering fees, but they're not charging me those fees. They're not deducting those fees from my royalty check. I have transportation fees that I'm seeing that are on the check, but those fees actually aren't being imposed on me. I'm not sharing in those costs. So I see them, but I'm not being charged those costs. Well, if Chesapeake gets this settlement approved, if this thing goes through the process and is approved, and other companies are sitting out there, what do we think that they're going to do? Are they going to sit there, and in this example, are they going to pay that landowner, continue to pay them 100% of these costs? And it's just this one example with only one well in 1 month. This particular landowner has a total cost, which are showing these post-production costs, of $2,233. Will this company continue to just pay that landowner 100%, this $2,233? Are they going to continue to pay this without taking any deductions when their competitor, when Chesapeake has reached a settlement with Pennsylvania landowners, which has been approved by the court if this were to all play out this way, Chesapeake is deducting 72.5% and only giving the landowner 27.5% of the money. Well, if you're another gas company, are you going to continue to pay your landowners 100% and not take any deductions at all when Chesapeake is only paying the landowner 27.5%? And you're going to continue to pay 100%? And we look at this, there are many companies, again, Southwestern, Cabot. If you're leased to Cabot, you're leased to Southwestern, you're leased to Talisman, you're leased to WPX, or you're leased to Chesapeake and Statoil owns a part of your lease. What is Statoil going to do? Under the same exact lease, I mean literally the same pieces of paper, Chesapeake is paying, and if this settlement were approved, and if it went through, which again, we are challenging on behalf of our current 160 individuals, over 5,000 acres. There's a reason why, obviously, we're challenging this. But think about this, though. You're leased to these other companies, or you're leased to Chesapeake and Statoil. Is Statoil, under the same exact lease, going to continue to pay you 100%? Are they going to continue to pay you 100% and not take any deductions whatsoever when their partner under the same exact lease, the same pieces of paper, are taking 72.5% and only paying you 27.5% of those post-production costs? Is Statoil going to continue to operate the way they are? Are they going to? Now, I can't answer that question, but I can tell you the fears that I have, and I can tell you the fears that my client has, or my clients have. We'll be right back. I'm going to talk more about this and give you another example right after this break. You're listening to All Things Marcellus with me, Attorney Doug Clark. We'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. And again, I want to remind everybody, we're here every Sunday from 8 to 9 a.m. And tomorrow, you can check it out. You miss any of today's show, go to pagasleaseattorney.com or pipelineattorney.com. Go to the websites, and we're going to post this show. It'll be up. It should be up tomorrow, Monday. If not, it'll be up by Tuesday, but we should have it up tomorrow morning. And so you can check it out on the website. Go back, listen to it. I know I'm giving you a lot of numbers, so you can go back, listen to it, kind of maybe focus some more, replay it and get these numbers. And I apologize, but the numbers are so important and they are hard to convey. And so I really want to try to do this in a way that you can understand it. As I always do, I have sitting here pages of information that I want to get to, that we will get to eventually, but with these numbers, it kind of gets a little bit slower to make sure that we're conveying, or I'm conveying this information in the way that you can understand it. I want to stress a few things. I want to stress, number one, that everybody out there, any listener, any leaseholder in Pennsylvania, needs to understand whether this proposed class action settlement applies to them. You need to understand that. Now, what you do with that information is up to you. I'm not sitting here saying you have to do anything. What I'm saying is I think it's absolutely necessary that you understand, does this apply to you? And then you make an informed decision as to what you want to do. You have to do this. This doesn't just apply to you. It applies to your children, your grandchildren. This is going to apply for the lifetime of your lease. That example that I just talked about in the last segment, remember, that is one well for 1 month. One well, 1 month. This proposal will apply for the lifetime of the lease. So we're talking, 20, 30, 40, 50 years, which is yet to be seen. Okay? It's going to apply to the lifetime of the lease and to each and every well that is drilled under the terms of this lease. So these numbers are going to change, and this is just one example. And relatively speaking, $2,200 in deductions out of an approximately $11,000 check, that's less than 20% or about 20% or so when you use the actual numbers. Well, there's people out there, and I have clients who are getting deductions in the 80% range, and I've heard of much higher even. So think about that. We're talking about this applying for the lifetime of the lease. The lifetime of the lease. So this is going to be for a very long time. And also each and every well. So if there were 6 wells drilled, these numbers, and it's not perfect, but and it wouldn't work out this way exactly, but the point is, hypothetically, imagine if you're timesing this by 6, if every single well was identical, which they wouldn't be identical, but just timesing that by 6 and what the impact would be, and then play that out over a number of years. Again, there's a lot of variables here, but just doing this for illustration, when I talk about a lot of variables, I mean you're going to have costs that sometimes are going to be higher, lower, the volume of production is going to fluctuate. Those are the variables I'm talking about. But the deductions and the settlement and the percentages, those aren't going to vary. So for the lifetime of your lease, if you are leased in whole or in part to Chesapeake, and this were approved, and again, we are challenging it, working on this literally about every single day, fighting this on behalf of our current 160 individuals as clients, on behalf of our clients who represent in excess of 5,000 acres. And that number is growing. Those numbers grow because more people are saying, hey, I want to contest this. I don't think this is good. I want to contest this. And what we're seeing is we're seeing more and more people as you become educated saying, wow, I don't like this. I don't think this is a good deal for me. And I've talked to many, many landowners. I've talked to other attorneys who represent landowners, and I haven't talked to one other than the group of attorneys who move forward with this, who say, hey, we think this is in the best interest and this is a good settlement for landowners. So my point is that you owe it to yourself, you owe it to your children, your grandchildren, your family, to get the information. Now, I am one voice. You can go Demchak versus Chesapeake. That case is available. It's filed in the Middle District of Pennsylvania Federal Court. Public record information. Go check that out. We filed our case approximately 5 months, like less than just 5 months, 1 day short of 5 months prior to this proposal. We filed our arbitration case, Burkett versus Chesapeake, in the AAA, American Arbitration Association, and that's a public record. Go to their website, look up information there as well. You don't have to take it as from me solely. You can do your own independent reviews and investigations, read the documents. We have many of the filings available on the websites. You can go to pagasleaseattorney.com or pipelineattorney.com, but on pagasleaseattorney.com, we have literally many of the documents that are filed in PDF form. You can read them if you'd like. Get yourself educated. And that's where I'm saying what I'm going to do. And if you've listened, this isn't something I've been preaching since this whole settlement and the royalty cases started coming about. You go back to August of 2010, and you'll hear me saying the same things. Become informed, become educated, make the right decision for you. Get your education, get your information. It doesn't have to be that you have to say, hey, I'm going to sign up. I want you to represent me. I want to oppose this. I want to go to arbitration. This is what I want to do. You get the information and then decide whatever it is that you want to do. And maybe you don't want to do anything. Maybe you say, hey, look, you know what? I think that's a good settlement. Maybe you want to write to court in support of the settlement. But get that information so you understand what's going on. This is it truly is a $1 billion plus issue, in my opinion. I mean, we look at these numbers. I see the impact on my clients. This is an enormous issue. The biggest issue facing Pennsylvania landowners right now with regard to the natural gas development is the royalty issue in many different ways. Well, here we're saying, company, you should not be able to take any deductions under the Market Enhancement Clause, Ready for Seller Use Clause, or similar language. And in fact, Chesapeake, look around you. Statoil, under the same lease, is not taking deductions. Many other companies are not taking deductions under the same language. Cabot, for example, Southwestern, Talisman, WPX. I keep repeating this because it's so important. So important. And if you're out there, like I said, and you're leased to these other companies, I'm keeping the closest eye on this as possible and saying, hey, this scares me, because what happens if my company, if Chesapeake is successful, how is that going to impact me in the future? Now, again, I'm representing landowners, our 160 clients, which again is growing. We're representing them in our case against Chesapeake. But as a side fact to all of this, what is going to happen in the future? We're trying to get the best. If there's going to be a settlement, we want it to be the best possible settlement and something that landowners can look at and approve. If there's going to go into court and we're going to fight it out, whatever happens is going to happen. But we're saying first and foremost, hey, look, this settlement is insufficient. And then we didn't even talk about, and I'll talk more about the release, meaning if this settlement were approved, what are you giving up? There's legislation out there. There's a movement afoot. There's a movement afoot to say, hey, you can't do these things. So we want to make sure, too, that if this were passed or if this is approved, can we still do an accounting in the future? What impact will future legislation have? Can we rely on that if it's going to be to our benefit? There are so many things to look at here. You, as a landowner, you owe it to yourself to become educated. And again, I am offering, and this isn't some gimmick, listen to the shows, go back 4 years. I want to make sure that you're informed. What happens is you contact me, I will give you a free, confidential, no obligation whatsoever evaluation of your lease. And just say, hey, this applies to you. And then if you want more information, you got it. If you don't, that's fine too. I'm not going to harass you. I'm not going to call you. I'm not going to keep writing you. We're not going to do that. We want you to be informed. I sit out here in the weekends. I sit in my office and I write these letters back to people and say, okay, here's what you got. This applies to you or it doesn't. I want you to be informed. I think that, I owe it to people to make sure that they understand. I would want to understand. I would want to be informed. If you want to find out, again, call me 570-307-0702. It's 570-307-0702. I'll give you a free confidential evaluation. Let you know, does this apply to you? You need to know that. All right, we're up against it. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Have a great week, everyone.